If you are emailing each other and everybody's using the reply all function and it's happening pretty quickly, that's probably a public meeting violation as well. If there's an email that goes out from one person to the rest of the board and there are no replies, probably you're okay. So the closer in time the communications are, if you've got a quorum and if you're talking about district business, that's when your red lights should be going off and somebody should be saying, you know, let's not do this way. Let's just wait for the next board meeting. This is not the appropriate venue to be talking about this.
I have a question on the quorum thing. What if two board members from one district are talking at a function, and two board members from another district aren't in the same board?
So the question is, you've got 2 members from one district and 2 board members from another district. They're all talking together.
Or 3 or
Sure. Enough folks that would create a quorum if they were all from the same district, but they're actually from separate districts, not a problem. You're talking about a quorum of your own board. But if you've got quorums of both boards, then that's a problem.
I'd like clarification on the quorum. Now, when say the 3 board members get together and they go to a meeting, is that considered a quorum? And when does that become a problem with the first open meeting?
So the question was really, how does quorum, the word quorum, work in relation to the public meetings law? Each of your districts is going to have a different quorum, and you establish that at the beginning. Usually a quorum is also a majority. We recommend that. But if you have a 5-member district, you usually will have a 3-member quorum. Anytime 3 members from your district are together and talking about district business, that's subject to public meetings law, meaning you can't go out to coffee. I don't care if you've been best friends since 2nd grade and you always go out to coffee every Saturday. I don't care, because guess what? Things have changed now that you're in public office. You get riches and money, right? Things have changed. You just can't do the same thing you used to do. You can go out for coffee and not talk district business. But I urge you to consider what the rest of the community thinks you're talking about. That's not illegal, but think about the appearance of impropriety. And they want to make sure that district business is in the open because it's their money. It's their stuff. It's the public's good, and they need it to be done in public.
What about if your board is going to a training session put on by somebody else?
Yeah.
And you've got the entire board or a quorum. Does that need to be publicized as a meeting, or can it just be noted in your minutes prior to that?
I always suggest, Lauren, I don't know if you disagree, I suggest you notify it, you notice it. There's an exception for trainings in the public meetings law. But why not just notice it, saying we're going to a training?
As long as it's not in Hawaii.
Excuse me? In Hawaii, we'll talk about that later.
Smart enough.
So I guess it would be the same answer for like an annual banquet that recognizes board members and staff.
There are exceptions to the public meetings law for things such as that.
I was just going to comment, Christy, that some of those situations, if you break up your members so you don't have a quorum sitting at the same table, it reduces a lot of suspicion.
Yeah, I mean, just think about what the public is thinking about.
So the next little piece that I want to quickly chat with you about is serial discussions, serial meetings. You may have heard about this because there was a fairly recent case out of Lane County where a couple of Lane County commissioners got together, talked amongst themselves, and then made a decision really, really quickly in a public meeting. And there was a lawsuit about it. And the judge said, look, this violates public meetings law. And so there's been a lot of discussion about that case and what it really means. And people have different takeaways. Mine is, it's not necessarily that serial meetings are a problem. Not necessarily. The problem that the judge pulled out of that case is that the county commissioners were doing basically everything that they could do to avoid making a decision in public, to avoid letting the public know what they were thinking, to avoid talking about a matter in public. So this was the issue that they were dealing with was a big issue in the county. There was a lot of hot feeling on both sides of it. And what the commissioners did, they didn't really want to go through all of that in a public meeting. So they met behind the scenes. They met never in a quorum, in groups of 2. But they lined up the votes beforehand. Everybody knew how they were going to vote. They showed up at the meeting. There was a motion, there was a second, there was a vote. The whole thing took about 2 minutes, and then they got out of there. And the public didn't have a chance to hear what they were thinking about the issue. The public didn't have a chance to understand kind of the way that the issue affected the county. They did everything that they could to take it out of the realm of public discussion and to keep the public from really knowing what they were thinking. And that's the whole point of the public meetings law, right? Is that the public has a right to know how their money is being spent, what their elected officials are thinking about, how the district's decisions are being made. So serial discussions, if you go talk to one board member and say, you know, we've got this thing coming up on the agenda, here's what I'm thinking, what are you thinking? And then you go talk to another board member, and then you go talk to another board member, never with a quorum. Not necessarily a problem, should maybe kind of raise some red flags for you and think about, what am I doing? Am I information gathering? Am I just kind of trying to find out where everybody stands so I know, you know, I feel this way about the issue, but the majority of the board feels another way, so I'm not going to bog down the meeting with a long discussion of my issue. Or are you trying to get the decision made before the meeting happens? If you're trying to get the decision made before the meeting happens, that's a problem. If you're trying to just kind of figure out where everybody stands and you still plan on attending the meeting and having the discussion so the public can understand what you're thinking, the public can understand what the other board members are thinking, probably not a problem. So I wanted to give you a little bit more discussion about that because I think there are some folks out there who have said, serial meetings, don't do it. Don't even talk to another board member without a quorum. All business should take place in the public eye. In a perfect world, that would be true, right? But then your meetings would be 20 hours long. So just be aware of your purpose in having discussions and what it looks like your purpose is in having discussions. And if it looks like you are trying to avoid making a decision in public, be concerned. If it looks like, and your intent is just to gather some information to kind of find out the lay of the land, probably not so concerned.
And I will go to the mat to argue that you have the right to talk to individual board members and talk about these issues. That's how problems get solved, like I said, over a cup of coffee. Figure that out. But just be aware when you're having several of these conversations in a row, and if you're vote tallying when you're doing it, saying, okay, you're with me, let's go talk to him. Okay, you're with me, let's go talk to him. You're with me, I'll talk to her. That is now going to be a problem.
Do all of those rules still apply with executive session?
So the question is,
Because, you know what I mean, because of the executive sessions are private anyway, so is it, you're still not allowed to talk with 3 or more people? You know?
so the question is, do the public meeting rules still apply in executive session? And the short answer is yes. Executive session is a subset of the public meetings law. You are still in compliance with the public meetings law as long as you are complying with the requirements of having an executive session. The public meetings law recognizes that while generally information should be open and available to the public, there are some instances where a board should be able to meet privately and talk about things like in litigation matters, for example. If you were a private citizen and you were in litigation, you would talk to your attorney without the other side knowing about it, right? Because that's attorney-client privilege. You want to be able to have private discussions with your attorney. If you had to do those in public session because you have a quorum and you're talking about district business, that would be pretty unfair to the district because the other side would know your entire litigation strategy. So there are some times where it's appropriate to meet in executive session, and as long as you are following the executive session statutes, you are still in compliance with the public meetings law. But you would still, if you're meeting in executive session, you're still gonna notice the meeting. You're still gonna have it in a place that's accessible to the public. They'll just be asked to leave the room for the executive session portion. You're still gonna take minutes, although they won't be available to the public. So you still kind of follow all the public meetings requirements. They just are dealt with in a slightly different way. And this is a great segue into the next slide. So speaking of executive session, there are very specific requirements that you have to meet in order to meet in executive session. You can only meet in executive session for certain purposes. You can't discuss any topic in executive session. And you need to make sure that when you meet in executive session for a particular purpose, to talk about litigation, for example, that you only talk about that subject in executive session. As soon as you stray onto a different topic, because the whole board's there and you're done talking about the litigation, and somebody says, well, what about that pipe that just broke down on West 2nd? What are we going to do about that? Oops, now you violated the executive session statutes. And when you do that, anything that you said in executive session is now fair game. Because I think, as you know, the media is allowed to attend executive sessions. The public can be asked to leave. But if there's a member of the media, they get to stay. They don't get to report on what they hear in executive session unless you violate the executive session statutes, at which point the whole ball game is open to them.
And let's talk about hallway conversations at this point. So executive session's over, you've done your job, you've properly noticed it, press has been there, and it's done. And then you step out into the hall, you're done with your meeting, you're talking with the reporter, and you start talking, because they were in executive session, right? They start talking with the reporter about the executive session. That's fair game. Don't talk outside of executive session. You could have just given away that your district is planning to buy a land, and tomorrow, the land price is going to go up, right? You just hurt your citizens by talking in the hallway.
The other thing that I want to flag about executive session that I'm sure you're all aware of, but just as a good reminder, is you're not allowed to make the final decision in executive session. You have to come out of executive session, go back into open session for the board to make a decision. You can talk about it in executive session, but when the motion is made, it needs to be in open session. So you close executive session and come back out. And the other thing that I want to plug for executive session is because the media get to attend, it's really important that we follow executive session procedures when you open the executive session. There's a script that someone, probably the board chair, will read that says the public is being asked to leave, the media is allowed to stay, but they can't report on anything that they hear. It's just a script, and it's actually available. The Oregon Attorney General's office publishes a public records and public meetings manual that I would encourage, if you don't have a copy for your district, I would encourage you to get one. It's really cheap. I think it's $20.
It's also online now.
It is also online. Thank you. And they have sample notices, sample executive session scripts, a whole bunch of stuff in the back of the book that's very helpful to you. And as long as you follow those scripts, you're going to be fine. But if you forget to follow those scripts one of those times, and forget to ask the media not to report on what they've heard in executive session, technically, they can report on what they heard in executive session. Or if you make a decision in executive session.
Do you advertise as a regular meeting? Do you have to advertise your executive session?
You need to provide reasonable notice for executive session, but you don't need to advertise. If you're in a public meeting and it's already been advertised, and you have your public meeting has already been noticed and advertised, and it's coming up that you think, oh, we need to go into executive session for this.
You do, actually. You do advertise your executive session, but it's usually part of the advertisement of the whole meeting. And you need to let people know ahead of time what the basis of the executive session is. So
Or your agenda then?
Yep, it'll be part of your agenda. You're going into executive session to consult with legal counsel. You're going into executive session to talk about real estate. You're going into executive session to talk about records that are exempt from public inspection. You need to lay that out in the meeting notice so that the public has a right to know the general scope of what you're talking about, even if they're not allowed to stay for the executive session.
So you cannot go into executive session ad hoc, found out that you're being sued the day before, it's not been noticed?
I wouldn't do it on the fly. So public meeting notices, generally, the purpose of a public meeting notice is to let the public know as soon in advance as possible about the general topics that you'll be discussing. You can notice a meeting up to 24 hours in advance, and it's fine. It complies with the public meeting notice requirements. So if you find out at 4 o'clock on Wednesday and your board meeting is at 6 o'clock on Thursday that you're being sued, yeah, quick. Send out notice that you're having this executive session on Thursday. There's a possibility to call an emergency meeting, which the notice requirements are smaller. In the case of an actual emergency. And it may be that litigation counts as an actual emergency. What you want to do is just try to get the notice out there as best as you can in the time that you have to let the public know that this is going on. And so usually there are a couple places in the district that notice is posted, put it on the website. You don't necessarily need to publish again if you publish notice in the newspaper, but if you're under the gun, but you still have more than 24 hours, post it where you post it, put it on the website. Do what you can to get the information out there.
I was just a little confused about the media thing. What's the point of the media coming to an executive session if we can't report on an executive session?
The question is, what's the point of the media being able to sit in executive session if they can't report? And the answer is to keep you honest. I'm sorry.
Gotcha.
Yeah, it is a little bit of a gotcha value.
Yeah, and they'll keep you honest, but they also know the background. I actually find if you have a good relationship with the reporter and trust the reporter, it can be helpful to have somebody who's educated on what the decisions you're making and the pressure you're under is about litigation, about something, so that when they do the story, it's actually more, they do understand some of the background.
Would you set an example of what these sessions before their emergency?
Examples of emergency sessions. For example, if you've had a CEO personnel emergency where you're fired, you need to take an employment action right away regarding your CEO. Or if you've been sued, or if you've had an emergency at the district, a death, or something to that effect, and the board needs to take action right away.
In previous seminars, when this question has come up, we've always been advised that if issues come up during a meeting, we have an issue came up that, or just hypothetically, that the EO, executive director was acting inappropriately, and we need to look into that issue, that we can go into executive session.
I'm a little more liberal than what Lauren was saying, but I think different attorneys come down. What I heard her say is if you've noticed the public meeting already, then that notice can provide the notice for the executive session. Here's what I like better. If you've noticed that public meeting and that subject matter was already in the public meeting, like we're going to talk about employment matter, and then you're like, whoa, wait a minute, we want to do this in executive session, and you turn to me and say, Christy, can we do this? I'm going to like it a whole lot better if you've already noticed the meeting and you've already noticed the subject matter. Does that make sense?
The question, I think, is also, do you need to do it tonight? You can add items to the agenda that were not in the published agenda. That's true. You can do it. But if there's ever a question, if there's ever a lawsuit, what folks are going to look at is, did you follow the spirit of the public meetings law? Did you do everything that you can to give the public prior notice that this is going to be discussed? If you truly need to take care of it now and you truly didn't know about it beforehand, yeah, add it to the agenda and do it. If you just found out about it, but it's okay, you can get another meeting together tomorrow or the next day, and that will be not too late to take care of the matter, I would say do that. That is the safer course. That is, as your lawyer, the course that I would recommend. If you know ahead of time that something's going to come up, and you don't have a lot of time, but you have 24-hour notice, get that notice out there as best that you can, that you're going to take on this topic that wasn't in the regular published agenda. So at some point, there's gonna have to be a balancing about what the district needs to get done and how much notice and how much time you have. But if you have time, publish the notice.
So can you do it? Yeah. Should you do it? Probably not. And you could probably avoid it.
Then you need the 24-hour notice.
That in an executive session has to be decided on in a public meeting.
Correct. No final decisions in executive session.
That's correct.
Can that 24-hour notice be met by giving notice of a future meeting at that meeting?
Yeah, but it's usually a published notice.
Well,
You,
you decide you're gonna do it, so you publish it, you know, and you get it out to all the.
yeah, I mean, give notice at the meeting, but also publish it as best you can.
One question. Is it okay in a public notice to say executive session under ORS such, if necessary?
So the question is it okay if you think you might need to go into executive session to set an executive session in your notice, and then that way you're covered if you decide to go into it or not? I think the answer is yes, as long as you have the right basis for the executive session. But certainly you could think that you might need an executive session and something happens and it gets resolved and you don't need to go into executive session. You're not forced to go into executive session just because it's on your agenda. You could skip over that and get to the next thing.
So there are 3 major rules. Ethics is a quagmire, but we're going to make it simple for you. 3 rules that I want you to remember regarding ethics. My goal here to talk to you about ethics is that not that you become an ethics expert, but that a little alarm bell will go off in your head when you hit the circumstances that may incur you ethics liability. So the first rule is the but-for test. Why do we call it the but-for test? Who here has had my seminar before? Why do we call it the but-for test?
But for your position, you would.
Oh, he knows it.
That's the real test.
That's it. Because it's going to save your butt for, right? All right. So a public official, you cannot get money or avoid losing money for you, your relative, or a member of your household, or your business, if that opportunity would not be available but for your position. What does that really mean? Somebody wants to give you money because you're a district board member. Who's knocking down your door to give you money because you're a district board member? You're paying money, right? You're paying gas, you're going to meetings. It's costing you. Welcome to the club. It's costing you. But these laws were drafted for legislators. That's why they're so hard to apply to your position, but you're still beholden to them. So just know that as we talk about that, these laws were drafted for legislators. That's the rule. Can't use your position, your official position, to get money for your relative, a member of your household, or you. How does that work on the ground running? Your district is purchasing, your district is purchasing, help me out.
Okay, so here's an example from an Oregon Supreme Court case from a few years ago. And this is sort of the avoid losing money piece of this test. So there was an agency director, I think it was for SAFE, and he was buying a fleet of vehicles for his agency. And he was getting a good deal, a fleet discount, because he was buying so many vehicles. And he was looking at the cars and he was thinking, these are pretty nice, and I could actually use a new car. I'm going to tack one more onto my order. I'm going to pay for it. It's not going to cost the state any money. I will pay for it, but I'm going to get one for myself. Somebody thought that was a problem. There was a lawsuit filed. It went all the way up to the Oregon Supreme Court, and the Supreme Court said, it is a problem because even though it didn't cost the state any money, this guy could not have gone down to his local car dealership and gotten that car for that price. The reason he got such a good deal is because he's the agency director of SAFE, and he got the fleet discount deal, and that is him avoiding losing money for himself, and the opportunity is only available because he was a public official, a state agency director, and so that is actually a violation of the ethics statutes, even though it didn't cost the state any money. So if you're getting a special discount, that could be an issue as well. If you're getting it because you are a district director.
I can't imagine anybody who say would ever do anything like that.
So this can happen with, you can have an ethics violation, a but-for violation if you're using district resources too, because you're getting a government benefit and getting money in your pocket based on your position as a public official. In a district, in Alaska, some district board members have used, I don't know, district backhoes to bury their dogs, or used district lawnmowers to mow their lawns. That's putting money in your pocket. You get a benefit you would not have gotten but for your position. Did it cost the district any money? No. Were the equipment just sitting there not being used? Yes. Doesn't matter. You don't get special treatment based on your status as a public official. That's what Oregon law says. Oregon law says that. Some states don't say that. Oregon law says that.
We heard a story this morning where they have a yard, like most fire departments or any kind of public utility has some kind of yard, and the guy was parking like an RV there or something. And it wasn't costing him anything, nothing else was being parked there, but if he would have parked it in another facility, they would have charged him to park it. And he's
Yeah.
parking it for free, so he could park it.
That's
He
okay.
avoided losing
Right.
money based on his status as a public official. You know what could happen? Goes to the ethics commission, gets splashed all over your newspaper, you get charged, you have to pay back the value. Let's say that RV was parked there for 3 years. How much would it cost to store an RV somewhere for 3 years? Got to pay back that value, plus you could be charged up to $5,000 per violation. I'm a hawk on this. If you call me, I will say, and if you're starting to parse, well, you know, Christy, it's not that much, I'll say, that's fine, but I'm trying to protect your bank account, and I don't want you on the paper. I want you protected. You're a volunteer, for goodness sake. I want you protected. So the next rule on ethics, this but-for rule doesn't include compensation or reimbursement. You can get reimbursed for your expenses. That's okay. That's somebody giving you money based on your status as a public official, but that's okay. Reimbursement's okay. Compensation for your employees is okay. Unsolicited awards or legal expense donations are okay. Why is that there? Legislators, right? Unsolicited awards, but that also includes like a plaque or something, or some awards that they gave you for, and gifts. Wait a minute, gifts are excluded from the but-for test? That seems like an awful big loophole, doesn't it? You're telling me I can't get any money based on my status as a public official, but I can get gifts? Well, next slide. Gifts are limited to $50 per year per giver, if that giver has a legislative or administrative interest in your actions as a public official.
And what does that mean, legislative or administrative interest? Because what does that mean, right? It means an economic interest, so it's money in their pocket or out of their pocket, that is different than the general public. So if you were making a decision on a bond measure that would affect every property owner in your district, probably the property owner, by virtue of being a property owner, doesn't have an economic interest in your decisions because it's the same as the general public. On the other hand, if you're making a decision about letting a contract, and you've got a friend who's a contractor who's trying to give you a gift, and they're eligible, I mean, they could provide the service that you are using this contract for, then you do probably they have an economic interest because they could get paid, right? In your decisions that is different than the general public. The general public doesn't have the same interest in that contract as the contractor does. So those are kind of two separate examples.
Let's use the city of Portland example, because it's not an elected official example, but I think it displays the point. This really happened. Way back when, they didn't have this test regarding legislative or administrative interests. They just said a gift is limited to $50 per year per giver. And so any giver who gave you a gift as a public official was limited to $50 per year per giver if that person had an interest in your government or worked with your government, I should say. So way back when, there was a sweet girl who worked in the city of Portland, and she fell in love. And she fell in love with a contractor, let's say. I think he was a contractor. I don't know what interest he had in the city of Portland. And she worked in the municipal court office. And he often comes to the city for contracts and worked with the city a lot. And he gave her a ring and said, will you marry me? And she said yes, and it was beautiful. However, this girl probably had taken art ethics course. And she said, wait, this is something of economic value given to me by somebody with an interest in the city, who works with the city. And maybe I can't get a gift from him. Can I get a gift from him? And the legislature talked about this, and they went ahead and made it a legislative interest or administrative interest in your decision. So if he had an interest, if she had been a
Purchasing manager.
Yeah.
Other side letting the contract.
yeah, exactly. So now it's that interest to you, but you as an elected official, whenever you're making decisions regarding parks, if you are making a decision about where to site a park, and your neighbor is very interested in where this park will be because it will affect some land that the neighbor owns, and the neighbor says to you, hey, Jim, you want to use my cabin for a week? And even if you've always used the cabin for a week, you need to think about that. That's the other theme that runs through this training is you're wearing a different hat now. And even if you've always used that cabin, you need to think about it. If he has a legislative or administrative interest in your decisions, and you're making a decision that's going to put money in his pocket or take money out of his pocket, you got a problem there. We'll talk about that more. Yep.
So this is just what we talked about. What is a gift? What counts as a gift? Something of economic value that's given to you, the public official, your relative, or a member of your household. So if you've got a friend who is crashing on your couch and has been crashing on your couch for a while, they are a member of your household, and technically these apply to them too. Without receiving value back. So you didn't pay for it. It was a gift. It was something that was given to you. And it's not given to the general public on the same terms. So if this isn't a great example, but say, those Bed Bath & Beyond 20% off gift cards that everybody gets in the mail all the time? Those are given to the general public on the same terms. They're not given to you because you're a public official. Everybody gets them. So even if Bed Bath & Beyond had an interest in your decisions, which they probably don't, you could accept those coupons because the public gets them as well. Next slide.
Can we talk a little about cell phones? 'Cause I think
Yeah.
we got to keep going. Okay. Talk to us about cell phones if you have questions later.
And we covered, this is what Christy was just talking about. Next slide. So conflicts of interest. We said we were going to give you ethics and 3 simple rules. This is rule number 3. And rule number 1 is the but-for test. Don't use your official position for gain. Rule number 2, gifts. Not more than $50 in a calendar year per giver. Rule number 3, conflicts of interest. And a conflict of interest arises, next slide, when you as a public official take an action, make a decision or recommendation that either could or would result in a financial benefit or a detriment, either way, you could get or lose money, to yourself, a relative, or a business with which you or your relative is associated. Next slide. So there are 2 types of conflicts. We've got actual conflicts, which is where your decision will result in a financial benefit or avoidance of financial detriment to you, your relative, or your public official. And then, next slide, we have a potential conflict where your decision could result in financial benefit or avoidance of financial detriment. And I'm seeing as I'm looking at the slides that they only say avoidance of financial detriment, but it's benefit or detriment. You get money or you lose money because of your decision. So let's think of an example, the difference between an actual conflict and a potential conflict. So for a potential conflict, sorry, this is more of a city example, but say somebody is serving on the planning commission and an application comes in for a zone change. And the property for which the application applies is next door to property owned by the planning commissioner. So this zone change is probably going to affect the value of the property for which the application was made, but it might also affect the neighboring property values as well. We don't know if they're going to go up or go down. It kind of depends on what is placed on that neighboring property, but there's a chance that the zone change could affect the planning commissioner's property. That is a potential conflict. That is a might. It could. The decision could result in a financial benefit or a financial detriment to the planning official. An actual conflict would be a district board member, a district is thinking about letting a contract, say they're gonna buy some fire equipment, and one of the district board members' spouses sells fire equipment, and the district decides to go with the company that the spouse works for. That is a financial benefit to a business with which a relative is associated, the spouse's business. That is an actual conflict, because they got the contract, they're gonna get the money. That is an actual conflict. So there are different ways of handling actual and potential conflicts as a board member. For both, if there's any sort of conflict that's coming up for you, if you think, gosh, this decision that I'm about to make either could or would create a financial benefit or detriment for me, my relative, or business with which we're associated, you gotta shout it out. You gotta declare the conflict in the meeting where you're making the decision. You gotta do it on the record. You gotta do it out loud. Then, next slide. Oh, here we go. Do it before voting or discussing, do it on the record. You only have to do it once per meeting, but you gotta do it each meeting that the issue comes up. And if you have a question about whether you have a conflict, you can always talk to your attorney, but you can always ask the Ethics Commission as well. Next slide. So you shouted it out. You told the public that you may have this conflict. Then if it's an actual conflict, if your decision would create a financial benefit or detriment, you gotta shout it out and then you gotta shut it up. After you declare the conflict, you don't talk about it, you don't vote on it, unless perhaps you're needed for a quorum. If the district can't take action without you, you may be able to vote, but you still don't get to talk about it. You don't discuss it, and normally you wouldn't vote on it. You declare the conflict, and then you're done. Next slide. Oh, sorry, backed up. So if it's a potential conflict, you still shout it out, but then you get to do what you normally do. You get to discuss it, you get to vote on it. So if it's an actual, declare that conflict, and then don't do anything else. If it's a potential, declare the conflict, and then you go ahead and talk about it, vote on it. No problem.
And it doesn't hurt you to declare. If you're taking a vote that could put money in your pocket at some point, the public, you live in small communities, we all live in small communities. This applies to small districts as well as big districts, but mostly the small districts, because they know your business in small communities, right? They know you've got a financial stake in it. Why not declare? It's no skin off your back, and then everybody knows you're being upfront. We're running out of time, aren't we?
We ran out of time.
So we covered all the bases. Really, these are the exceptions to the conflict rules. And if you have questions about, you think you may need an exception to a conflict rule, email me, come see me later, we can talk about it.
And the very last couple of slides have to do with nepotism, and the general rule there is don't hire, fire, or supervise your relatives.
Thank you.